We're here to discuss how to maintain an open and innovative internet, but also protect people's privacy and tackle bad content at the same time. Before we jump into the conversation, I would like to put to the audience a poll question to kick off the conversation. As a reminder, I don't think the web link is there, but as a reminder, you can access the polling at bloombergstyt.com. And yes, the question is, what impact has GDPR had 1 year on since its implementation? It has given me back control over my data. It has thrown up counterproductive hurdles to innovation online. It has not done enough to make tech companies accountable, and it has had no noticeable impact on my life. So, Helen, you can see some of the responses there. Still coming in. Quite a large number is saying it hasn't had a noticeable impact. But so maybe we can start there, Helen. I don't know. You had some thoughts about our poll, so maybe you can start with that.
Yeah, I mean, if I could offer a gentle critique of the poll, I think the options provided to the audience are somewhat negative. 3 of the 4 are designed to give a negative outcome. And in fact, the first choice is somewhat blunt and extreme. Even I wouldn't say the GDPR has given me back control. There still isn't enough choice in the market to make a statement like that, but I think it has given me more control. So just a gentle critique, I would say, of the survey. In terms of the last one that's showing up, the biggest number of responses, it has had no noticeable impact on my life. This has been a debate about the GDPR. Is it really a tool that empowers and impacts individuals very directly, or is it more a supervision tool for regulatory authorities like my office in terms of our supervision of big tech companies and all other types of organizations that process personal data? And I think it is intended to be both. So I hope over time, we're only 1 year into its application at this stage, that if you run the poll again next year and the year after, people will start seeing that greater impact. Just to comment, in the week that we're in, the EU Commission recently, to mark 1 year of GDPR, commissioned a special Eurobarometer survey. And what that survey has shown is that 67% of people, they surveyed 27,000 people across the EU, 67% of those respondents are aware of the GDPR, so that's a start, and 57% of them are aware that there's a dedicated supervisory authority in their member state responsible for regulating under it. And they say this is a 20% increase over the same survey questions when they ran them in 2015. So I think compliance on the part of organisations and more empowerment on the part of individuals starts with awareness, and at least that's a big measurable success of the first year of GDPR. We're moving towards that greater awareness as a starting point.
And Mitchell, what about you? I mean, Mozilla has always been a pretty privacy-conscious company, but has it had any impact on Mozilla or more broadly?
Well, on the Mozilla operations, very little. I mean, we didn't change our privacy policy for the GDPR. It was already, in that zone. I would say that what we see from the GDPR is, one, Europe looking for some way to say that the status quo is not acceptable and that somehow something is going to change. And starting with regulation or a supervisory approach, which, at Mozilla we have always believed is part of an answer, right? Government exists, it has a role. So GDPR as a statement that something has to change, I think is effective. What that is and how, and can the GDPR alone accomplish it? Probably not. Like, what really needs to change is interoperability, innovation. Where does who owns that data? Can you get it? Is there a mechanism by which it can be made available for innovation by citizens? And those are not the things that the GDPR is currently set up to, as it's as its focus. So I think we have a learning process with the GDPR, maybe from the supervisory role, but the signals and the learnings for what is innovation and if there's regulation, what is the regulatory framework that encourages innovation as well, which I would say is an interoperability and a portability of data and moving some of these things out of the we sucked it up, therefore that's where the data is. So we've seen it as effective. We've also seen it as a signal elsewhere in the world that something can be done, but expect that there are odd consequences. And this one about, yes, it's hindrances to innovation. Well, that's not surprising.
So one of the big features of the GDPR is that the national privacy regulators have, much more robust fining powers now. And Helen, given that so many of the U.S. tech giants are based in Ireland, that leaves quite a heavy workload for you and your team. But Ireland has also had this reputation in the past that it's very cozy with U.S. tech companies who in turn have invested heavily in the country. Do you feel pressured at all to aggressively pursue U.S. tech giants in order to dispel that notion?
No, we feel huge responsibility to regulate fairly and effectively under the GDPR. What we're required to do is to enforce and implement and apply sanctions, including fines, in a way that's effective, dissuasive and proportionate. So that's what we focus on. You say Ireland has been cosy with companies for a long time. It's probably hard to dispute that as a statement, in that we're a small open economy that's had a policy of attracting foreign direct investment for years. Intel, as an example, is over 30 years in Ireland, long before data protection laws came into vogue. But it's very important to distinguish between Ireland and the independent supervisory authority in Ireland. We are completely independent of government, and this is recognised under EU law. And we're independent of government precisely because I equally supervise government in terms of its personal data processing operations. And for any supervisory authority in the EU, they will all tell you that it's the regulation of public sector entities and government departments that often gives rise to the most headaches and which gives rise to the issues that are of most concern to the citizens in that country. So the supervision of government and the independence from government is extremely important to our office and is underlined by our office every day in terms of our activities. So if you look at the span of large-scale investigations that we've opened as a supervisory authority since the GDPR came in, we've about 54 large-scale inquiries or investigations open now, in addition to all of the individual complaint handling we're doing. And of those 54 investigations, approximately 36 of them are in respect of national or domestic issues and not in relation to big tech. So just over 20 of them do relate to big tech companies, because companies like Facebook, as an example, with over 1.5 billion users globally, they're always going to be in scope in terms of the amount of personal data they're collecting and processing and the potential risks for individuals. So it's appropriate that they are certainly part of the picture, but they are only part.
And moving now to the debate about self-regulation versus regulation. Mitchell, Mozilla is part of the EU Code of Conduct on disinformation that Facebook, Twitter, and other tech companies are part of. It was a voluntary code of conduct. The idea was to help combat disinformation on their platforms. And I think it's been about a little over a year since it's entered into force. I'm curious what your takeaway from that experience has been, and do you think it's an effective form of self-regulation for a tech company?
Right. Well, let me step back for just a moment to the bigger picture, and I think the question of is self-regulation alone enough has been answered. Right? Like even the big tech companies themselves have pretty much all said, we understand there's regulation. We understand the days of we did whatever seemed right to us. I mean, and there are a lot of people working very hard to do good things. Whether you think the results are acceptable or not, I mean, I'm not demonizing the individuals involved, but the companies, you know, have had a period of doing what seemed right, and I think everyone understands that's over. And now the question has shifted to, well, what kind of regulation and good regulation, and so I think the cynical could say, well, that's a much more winnable battle for the big tech platforms because you can spend forever talking about what's acceptable or good regulation. So I think the idea that this industry will self-regulate is gone. And that puts it like every other industry that has significant power and resources and capital and impact on society. And so if you take, you know, I don't know, take automobiles and safety regulations. Yes, I mean, we understand they might accept impact profitability and that there's certain things that must be done because that's important to society. So figuring out what that is for tech companies is the phase that we're in. And I think that could be long, very complicated. And I think that's where we're going to end up with the discussion. And there's clearly a lot of lobbying going on. I'm from the state of California, which has tried to enact essentially the GDPR as state law. And the lobbying inside California to reduce that to something smaller is really intense. So self-regulation, I think, is still important as we experiment with things. And so content is one. What does that look like? But I'm still hopeful that self-regulation in some areas where things are unsettled will be adequate. But as a general rule, I think we're past that.
Well, you touched on it a bit in your remarks, but you know, one example that we're all familiar with is Mark Zuckerberg's recent call for more global web regulation, and in particular, he says that it would be a good thing if more countries implemented GDPR-style legislation. Helen, your team has at least 8 open investigations into Facebook over possible breaches of the EU's privacy rules. I mean, what do you make of his comments?
Yeah, and if you add in WhatsApp and Instagram, it's actually 11. I mean, I think Mitch has phrased it correctly. The era of self-regulation alone is over. But in answer to your question about the GDPR and whether his call for more GDPR-style laws, actually, sometimes people talk about self-regulation in very pejorative terms, but the GDPR really recognises the role of self-regulation, so that demand that all organisations be accountable under the GDPR and demonstrate their accountability and how they're taking responsibility for personal data is an extremely strong underpinning facet of the GDPR, but what it's equally saying is that it alone isn't enough. It has to be backed up by that strong ex-post enforcement by supervisory authorities, which is where the investigations we have underway come in. So I think we do need both. Clearly, we're now an authority with 137 staff as of this week. We're responsible for supervising hundreds of thousands of organisations, in fact, and even the largest data protection authority in the EU, which is the UK Information Commissioner's Office, with, I think, close to 700 staff currently. The maths simply don't add up if you look at the quantities of organisations that we have to supervise. So in the first instance, organisations do have to self-regulate. They must take on board the principles under the GDPR. They must conduct the analysis, appoint data protection officers, implement the data protection impact assessments when they're going to implement a new technology, conduct those balancing tests to ensure that the interests of the individual are properly recognised in whatever implementation they roll out, and then the ex-post enforcement comes in. So I think we do absolutely need both, otherwise it isn't scalable. But I think in terms of the call for more laws like the GDPR, the more convergence we have, the better from the point of view of a supervisory authority like ours. the more supervisory authorities that look like EU supervisory authorities, that speak the same language and conduct their investigations under the same legal frameworks, the more effectively I think we can drive results. So I think it's a positive conversation.
I'd like to add a nuance there. I think the discussion about self-regulation alone is over, but I think the reality is that we don't have those laws. There's the GDPR, but the laws about online content or harmful content, those are coming. It's unclear what harmful content is. So there's a range of questions that are out and open. And so that's why I say this discussion about what are the balances. I mean, the EU directive on harmful content, or terrorist content, and then the French principles on harmful content, which includes tons of potentially legal content. Like those are long, complicated conversations.
Well, yeah, I mean, I'd be curious to hear more about your thoughts there. I mean, is there the whole undercurrent to this discussion is about this feeling that many users are losing trust in the functioning of the internet. So, but I mean, what impact could overregulation have on users' trust of the internet?
Well, the draconian impact of overregulation and bad regulation is you set up a totalitarian state and you kill innovation. Right? Where someone unknown is regulating all content. Is it harmful? Is it not? By some black box AI doing something, which is unclear, and which, because it's a law, the government now has the power to stop anything. And at the same time, these are systems which are potentially, implementable only by the giants. And so, what do you do with innovation? So, that's the end result that you're trying to balance against.
And Mozilla has urged caution to some of the EU policymakers, in particular about the terror regulation. I'd be, if you could tell us a bit more about, what your position on that is, and whether it's changed since Christchurch, for example. Why or why not?
Okay, let's see. So the underpinning of user-generated content is this intermediate liability, which says that a big platform like Facebook isn't responsible for what you as a citizen post. I mean, that's a simplified version, but right. And so that's been the basis for this. Platforms do really very little, and they have this safe harbor for content. And so a lot of the discussion is, we have to protect that, we have to protect that. But the reality is the reason for that is so that individual citizens can speak. The goal of intermediate liability is not to protect the few giant platforms. The goal is so that citizens continue, at least in the democratic societies, the ability to actually speak. And so our input has been, well, let's focus on that. And hold the platforms accountable for their processes. What kind of due diligence do they have? So that the first reaction is to say, platform, you have to take down anything that's X within 1 hour. I mean, in terrorist content, literally 1 hour. Anything. We're not defining what it is. You just filter and take down whatever. But it's not saying, gee, if you're a large platform, if you're monetizing it, if your algorithms are redistributing it, if you found terrorist content and it turns out to be incredibly profitable to you because of the way you redistribute it, those are the processes that needs to be fixed. And so our input, and Jeremy Wright has also been an effective advocate for this, is to say, let's actually hold the companies accountable for their business practices, and if they're monetizing things like terrorism or radicalizing content, let's look at the processes they're using, and let's hold them accountable for applying acceptable diligence. And if you're a small little company, that's one thing, and if you're a giant, your processes should be bigger. I mean, your profits are clearly bigger. The impact and damage you can do is bigger. So rather than say, the citizen suffers because there's this rule that anything that could possibly maybe be attached to liability is obligated to be removed, let's actually look at what the businesses are doing and how they're running their businesses, and have due diligence and proportional requirements as we do in many other areas.
And Helen, I mean, to what extent do you consider, these competing rights of an open internet or access to information, freedom of speech, to what extent do those values, rights, play a role in your investigations on privacy?
They play a significant everyday role for us as a supervisory authority, and really the Costeca judgment, if you recall it, from the Court of Justice of the European Union in 2014, that so-called right to be forgotten case, that really highlighted the role that we have as supervisory authorities in pointing out that search engines like Google, being the biggest, are responsible in terms of the personal data they process when they're returning URLs, when they're indexing. So if a search is conducted on the real name of an individual and it returns a URL where the information is irrelevant, inaccurate or out of date, Google and the other search engines are responsible for delinking it under that right to be forgotten. And there was a huge outcry when the Court of Justice made that ruling back in 2014. Many said it was an attack on free speech and the associated right to access information. But actually, I think what we've seen since 2014, Google has received, I think, in excess of 3 million requests for delinking, de-indexing, and as an office we've dealt with hundreds of complaints from individuals who've been dissatisfied with the response they've received from search engines. But I think if you analyse what's happened since 2014, it actually has delivered an appropriate balancing of rights. In about 43% of cases, Google accedes to the individual's request to take down, so they're not taking down in every case. And in terms of the complaints we receive, it's about the same percentage where we concur with the individual and where we don't. So I think there are circumstances where the privacy interests of an individual do trump the economic interests of the search engine and the right to access information in those subtle circumstances of irrelevancy and out-of-dateness in particular.
So I'll take a question from the audience here. Someone is asking both of your opinions on what new rules do you think the Internet needs going forward, if any? You can also say none.
Yeah. Well, I'll start, and I'll start in broad terms, and then maybe we can work our way to specifics. I would say that the accountability mechanisms are inadequate. Right, that turned out that the architecture of the Internet was able to scale in ways that were unimaginable when it was, physicists exchanging links and data. To go from that to what we've done today is because the architecture of the Internet, we call the open architecture, was designed to be distributed and to scale. So wildly successful. At the same time, the accountability mechanisms built in that era did not scale. I mean, there was social engineering, there were accountability mechanisms, there was a consideration of the kinds of harms that might occur and how the system would adapt to them and respond to them. But those did not scale to the scope of humanity. So I think the larger question is, how do we get accountability back into the system? And so that will cover everything. Right? I predict over time corporate structures will be looked at. Is the corporate structure as we currently understand it correct? It's a 20th century structure, some cases even a 19th century structure. And the ways that they've been evolving right now, and Mark Zuckerberg is a prime example, is absolute control. Right? The power of the capital markets behind him in a public company with absolute control. That's a modern change to corporate law. Is that right? So what does that actually look like? I think legal standards will be changing. Like, what are actual crimes? And what is, what are violence and threats of violence going to look like? And I think I had a fascinating discussion last night about how we account for capital and the cost of capital. Really, I think a question of which externalities can be modeled into the cost of capital so that financial structures and analyses might change. I think all of that will happen, that the changes that the network and the connected nature of society are bringing are just beginning. And most of our financial and legal and corporate structures have not responded yet. So all of those will change.
Do you have any?
I think there are lots of new rules that need to be debated and considered. The one Mitch mentioned earlier about the intermediary liability, sorting out whether platforms should be subject to media and broadcasting style regulation and all of those issues. But to focus on one that's of very direct relevance to my office and one of significant concern, it's the issue of children and the internet. The whole original concept of the internet was that it was to be democratic in terms of access and how it could be used. And the problem, of course, with a democratic system like that is that it treats children like adults. It treats all humans as the same, and it doesn't account for the evolving capacities of children, which we do in every other aspect of life. So the GDPR has now, for the first time in data protection terms, called out that children merit specific protections, that they may be less aware of the risks. But it doesn't tell us what those specific protections should look like. So as a supervisory authority, we launched a very large-scale consultation, I should say, towards the end of last year, where we're consulting broadly on how children should be able to exercise their rights, particularly as concerns internet platforms, how age verification should be done, if the approval of parents is required, how should that be validated, and so on. Very important questions that we still don't know the effective and proportionate answers to. And an important part of that consultation that we ran was a stream of it where we went out to schools and developed lesson plans that were delivered through teachers in order to gather the views of children age 8 to 16 directly. And we got fascinating responses from those different age groups in terms of their understanding of risks. So I think in due course we're going to need new rules that are going to better protect child users on the internet.
That's great. I mean, I'm sure we could keep talking about this for hours. Unfortunately, our time is up. So I would like to invite everyone to thank my wonderful panelists. It was really interesting to hear from them.